Welcome. I'm Peter Afrasiabi, partner at the law firm of One LLP, and this program is Secret Service Law, protecting the president, First Amendment access, and taking a bullet. Everything you ever wanted to know about the law that regulates the Secret Service and their protection of the president. It's the latest in our ongoing series known as The Curious Lawyer that lets you take a walk through different, fun, interesting areas of the law that you may not get exposed to in the rest of your regular continuing legal education programs. So let's get started, and on this first slide you see the issues that we are going to address today. The issues for the curious lawyer. The first one is 18 U.S.C. 3506. That's the governing statute that governs the Secret Service, its mandate, and what it needs to do and how it needs to do it. We are going to look at the history of the enactment of that statute and its broadening over time. We'll look at the protection and other duties of Secret Service agents, and we will look at the interface with the First Amendment vis-a-vis news gathering activities and how that collides often with the efforts of the Secret Service in terms of how they are protecting the president. We'll look at the Secret Service's jurisdiction over the White House, and then their broader jurisdiction in terms of federal crimes and what the mandate is of the Secret Service vis-a-vis federal criminal behavior and the FBI in terms of their jurisdiction and the overlapping areas. So let's get started, and we're going to start on the historical legal evolution of the United States Secret Service. And you just see on this intro slide there, that's a picture of one of the very early badges of a United States Secret Service agent. The history of the legal development really begins in the 19th century. And the legislation that created the agency was actually on President Abraham Lincoln's desk the night he was assassinated. It was literally awaiting his signature. At the time of his assassination, the only other federal law enforcement agencies were the United States Park Police, the United States Post Office Department's Office of Instructions and Mail Depredations, which is now known as the Postal Inspection Service, and also the U.S. Marshals Service. But the marshals at the time didn't have the manpower ultimately to investigate all the crime within federal jurisdiction. And so the Secret Service was then formed in 1865 within the Department of the Treasury. And the story within the 19th century and then also the 20th century and even the 21st century, as we'll see, is the story of jurisdictional growth. So it begins, of course, in 1865, and it was founded as the Secret Service Division, and it was designed to combat U.S. currency counterfeiting that in the post-Civil War period was rampant. It was estimated that over 13% of the currency at the time was literally counterfeit. And so the original scope of the Secret Service was really just focused on counterfeiting. But by 1867, that jurisdictional scope expanded from counterfeiting to also include frauds against the United States. And specifically what the U.S. Secret Service was focused on at the time was smugglers, bootleggers, non-conforming distillers, and even folks engaged in mail and land fraud. As the 19th century wore on, by the end of the 19th century, it was broadened even further, and it covered other federal criminal investigations beyond just those frauds and the counterfeiting. And ultimately, it was the first domestic counterintelligence agency, real precursor to the FBI, in other words. The next slide brings us now to the early 20th century, where in 1901 there was the McKinley assassination, and the U.S. Secret Service's powers were then broadened to protect the president. And this was done in an informal manner. Then in 1909 there were assassination attempts on President Taft, which again led to the broadening of the U.S. Secret Service to start focusing on protecting the president and being a presidential protection detail. By the mid-20th century, we got to 1950, and specifically on November the 1st, 1950, there were some assassination attempts on President Truman. And what actually happened is as follows. There were two Puerto Rican nationalists who mounted an assassination attempt on President Truman. The president at the time was living at Blair House while the White House was under renovation. And the assassins stormed into Blair House. They actually were shooting, and they shot Private Leslie Cauffield of the White House Police Force 3 times in the chest and abdomen. Despite his wounds, he actually managed to return fire, shooting one of the assassins in the head. Kofelt, however, is the only member of the Secret Service to die while protecting the president because he later died of his wounds, unfortunately. And so that had a big impact on the U.S. Secret Service and on the Congress, which then expanded the jurisdiction of the Secret Service to formally protect the president in a more regimented way. In 1963, the legislation was again expanded to give the wife of now slain President Kennedy, Mrs. Kennedy, and her children years of protection, 2 years of protection. And in 1965, the legislation was broadened yet again to cover wives and children until the age of 16. 1968 brought, of course, Robert F. Kennedy's assassination in Los Angeles, and new laws were then passed within the jurisdiction of the U.S. Secret Service to lead to the protection of presidential candidates and also the provision of lifetime protection for spouses of deceased presidents, unless the spouse is remarried, and their children until the age of 16. In 1984, as the 20th century was coming to a close, the Comprehensive Crime Control Act of 1984 was passed, which expanded the jurisdiction of the Secret Service to cover credit card and the computer fraud that was then beginning to burgeon. By 1998, an executive order was issued by the president creating the National Special Securities Events, with the Secret Service being responsible for those events that are designated to be National Special Security Events. The 21st century brought further legal changes to the jurisdiction and scope of the Secret Service. This all began with 9/11, of course. On 9/11, the New York City field office of the Secret Service was actually located at 7 World Trade Center. And so after the World Trade Center was attacked on September 11th, special agents of the Secret Service and other field office employees were actually among the first to respond with first aid. There were 67 of the special agents of the Secret Service in New York who helped set up triage areas and helped evacuate the towers even. And one Secret Service agent, Special Master Officer Craig Miller, actually died during those rescue efforts and then was subsequently awarded the Director's Valor Award along with others for all of his efforts and valor that day. As a result of 9/11, the newly created then Department of Homeland Security, which came as part of the Patriot Act and other legal changes to the federal executive agencies post 9/11, led to the movement of the Secret Service from the Department of Treasury now to the Department of Homeland Security. It also led to an expanded focus on computer crimes and mandatory electronic crimes, with mandatory electronic crime task forces set up around the nation to investigate and monitor financial fraud. So, the historic arc we see here of the U.S. Secret Service is that it has a growing jurisdiction and a growing roster of duties as time has worn on, from simply counterfeiting to today covering all sorts of financial counterfeiting, electronic computer, currency fraud, as well as protecting the nation's leaders and presidential candidates. The first question then we get to on the next slide is, who is protected today? And that's a photograph of presidential candidate Robert F. Kennedy speaking at Berkeley back in 1968. As we see on the next slide, the first category of people protected involve the president and the vice president and their families. And so under 18 U.S.C. 3056, the Secret Service is charged with protecting the president, the president-elect, the vice president-elect, and their immediate families. Secret Service is also charged with protecting former presidents and their spouses for their lifetimes, except when the spouse divorces or remarries, and the children of former presidents until the age of 16 or 10 years after the presidency. It also includes the widow or widower of a former president who dies in office or dies within a year of leaving office for a period of 1 year after the president's death. Former vice presidents, their spouses, and children under the age of 16 for up to 6 months from the date the now former vice president leaves office. And it's under the Secretary of Homeland Security's discretion to extend the protection time if the Secretary so decides. The next question is, how is the president protected? Well, as you see here, one of the most critical points is that the Secret Service is always near the President of the United States. They're always hovering around POTUS, in other words. Jurisdictionally, the U.S. Secret Service has the authority to designate the grounds of the President's locale for security, and this is governed by the implementing regulations in 31 CFR section 408.1. What's important about the Secret Service's jurisdiction to designate and define the president's grounds are that the president, of course, is a person. He or she moves around different locations and different physical geographies and areas, and this then facilitates and enables the Secret Service on an advanced basis to go out and redefine his locale and redefine the grounds by which he is on that facilitate then his ability or her ability to be on those grounds and have no one else on those grounds or within designated areas. It's a sort of roving, moving, jurisdictional blackout zone in effect. The Secret Service gets to define who may access the president's grounds, so to speak, and there's a variety of requirements under the Code of Federal Regulations. The Secret Service must be in receipt of identification of the person that's satisfactory to the Secret Service. And then there are certain circumstances that govern who may access and those circumstances. The first involves, of course, invitees, those invited or having appointments with the President or his staff, or a member of the Vice President and his protectee staff. Members of the staff are covered. Military and communications personnel assigned to the office of the President are allowed access. Federal, state, and local law enforcement personnel engaged in the performance of their duties and whose presence is necessary to provide services or protection for the premises thereon. Holders of grants of easement to the property at issue, provided their persons or their authorized representatives show and prove title of that easement and obtain authorization from the Secret Service. So you can see there's a very comprehensive and developed federal regime that's been created to allow the Secret Service to define who may access the president, depending upon where the president may be. And one fascinating little footnote here is that even when the president is alone in the Oval Office, there are actually sensors under the floor of the Oval Office that facilitate the Secret Service to know exactly where the president is within the Oval Office. Kind of fascinating little tidbit to history there. The next category of people protected involve others beyond the president and vice president, of course, and that involves visiting heads of state and their spouses traveling with them, other distinguished foreign visitors to the U.S. and official representatives of the U.S. performing missions abroad, those that may be directed by the president, and quote-unquote major presidential and vice presidential candidates, spouses, families within 120 days of an election. Now, the word major is in quotes because the legal question is raised, what is a major presidential candidate versus a non-major or minor presidential candidate? Well, federal law, again, the governing Secret Service statutes define what is a major presidential candidate or vice presidential candidate, and it is defined as follows. Major presidential and vice presidential candidates mean those individuals identified as such by the Secretary of Homeland Security after consultation with an advisory committee consisting of the Speaker of the House, the Minority Leader of the House, the Majority and Minority Leaders of the Senate, and one additional member selected by the other members of the committee. So a group of committee members from the House and Senate get together and they get to define what is major and what is not major. The next question that the governing law really addresses is whether this protection being provided by the Secret Service is mandatory or is it discretionary? May the recipient decline it? May the recipient not decline it? Well, as it turns out, for the president and the vice president, for the president-elect and the vice president-elect, protection is mandatory. So the president is unable, despite being president of the United States, given the legal framework, the president is unable to tell the Secret Service to leave him alone and not protect him. As to all others, it's actually discretionary. And so, for example, in mid-2017, Donald Trump Jr., who had protection, being the son of the president, gave up his protection and didn't want a protection detail anymore. And these legal provisions are housed in 18 U.S.C. 3056, subsection A. The Donald Trump Jr. example is fascinating because what it gets to, as you see on the next slide here, is a very real and present legal problem, in effect, that has befallen the Secret Service, and that is really the limits of their capacity to protect and defend are being stretched. During President Obama's terms in office, there were 31 protected people. During President Trump's term thus far, there are 42 protected people, and this is numbers as of late 2017. By mid-2017, the budget limit for the entire year had been hit by the U.S. Secret Service with their agents and the overtime that was required. And so the issue this raises is the need for Congress to appropriate more money and solve this riddle that is, plaguing the Secret Service in terms of limiting its capacity to actually perform the mandated duties that the federal law imposes on it to provide. The next question is, how long does protection last? That is provided in the President's Protection Act of 2012. This is codified at 18 U.S.C. 3056, and it provides, at least under current U.S. law, that presidents are protected for their entire life. The children of former presidents are protected up until the age of 16, and former vice presidents are actually not covered anymore. So if you're going to want U.S. Secret Service protection for the rest of your life, become the president and not the vice president. That's the tip for today. Now, as you remember earlier, I mentioned that in the late 1990s, during President Clinton's presidency, there was an executive order issued that enabled the president to declare certain national events as being the type of events that are sufficiently significant that the U.S. Secret Service should participate in providing security and safety and infrastructure to help the security and safety of those events. This began in 1998 with President Clinton's executive order, and the result is that there have been a variety of different events that have been declared significant by the president, by a series of presidents since President Clinton, and require U.S. Secret Service participation. Super Bowls have been declared such events of national significance, and so the U.S. Secret Service will actually participate in the security and the safety of the Super Bowl events even when the president isn't there. So the president doesn't have to attend, the U.S. Secret Service will always attend. World Trade Organization events have been designated as being events of such national security significance that the U.S. Secret Service is required. The Olympics, of course. G8 and NATO summit meetings that occur in the United States have been declared as being similar type events that require the U.S. Secret Service. And subsequently, also, we've included presidential inaugurations, State of the Union speeches, and even the conventions of the Democratic and the Republican national parties. All of those have been deemed national events requiring U.S. Secret Service participation. What exactly does the protection include when the U.S. Secret Service is there doing their protection behavior, right? Well, at a minimum, it includes actual physical protection. That means they are physically nearby in order to protect and defend from an attack or an assault the protectee. It also includes transportation and the use of government employees being provided to the protectee in order to facilitate protection efforts. So the actual physical protection will extend to the use of vehicles, transportation, and other staff members to facilitate the ability to protect. And interestingly, the U.S. Secret Service can actually enter the flight deck of any commercial airplane when they are on that plane with any protectee if they consider it necessary for their duties. So it doesn't have to be just the president, who of course rarely flies on a commercial plane, obviously, but it could be any protectee that the Secret Service is protecting. If they believe that it's necessary for their duty to enter the flight deck of the airplane, they may enter the flight deck of the airplane. This brings us to the idea of protecting former presidents' children. And this is a case study involving paparazzi, the Kennedy children, and the First Amendment. And there you see a picture of President Kennedy's wife, Jacqueline Kennedy Onassis, and his son, JFK Jr., biking through Central Park in the late 1960s, early 1970s or so. And this triggers and raises the case of, as we see on the next slide here, Galea versus Onassis, which is reported at 487 F. 2nd, 986. It comes from the Second Circuit in 1973. Galea really was the architect of the whole modern world we live in when it comes to celebrities and paparazzi. He was sort of the original self-proclaimed paparazzo who really stalked Jacqueline Kennedy Onassis and her children in public in order to get photographs and sell those photographs for vast amounts of money. And of course, in the 21st century, we're all familiar with paparazzi and their photographs of celebrities, which fill all magazines and all newspapers and all internet websites with a whole massive variety of fascinating content. But back in the early 1970s, before obviously the advent of digital and the internet, Galea was really one of the first who created this whole industry. And what was going on was Galea would repeatedly sort of jump out in front of the Kennedy family when they were, riding their bikes, like in that picture, in order to get photos. And the facts that gave rise to this case were as follows. Galea was out there one day, and Jacqueline Kennedy Onassis and JFK Jr. were riding their bikes, and they were going through Central Park. They had Secret Service agents with them, and Galea jumped into the path of John Kennedy Jr., and he had to swerve his bike dangerously as he left Central Park and was about to enter Fifth Avenue, and they feared that he could have gone into oncoming traffic or been injured. And so because Galea was leaping about and jumping about doing his whole paparazzi thing, the agents gave chase, and they chased down Galea, who took off running to avoid being caught, of course, but nonetheless he was caught. I guess that's another footnote. You can't outrun the Secret Service, apparently. So the Secret Service took him down to the police station, and he claimed, hey, look, I'm a photographer, I'm a press photographer, I've registered with the New York City Police, I'm legit, I have the right to be going and taking photographs in public. But nonetheless, down at the police station, one of the Secret Service agents swore out a complaint against him, saying that he had imposed unreasonable danger on the family that they were protecting, and that he needed to be, stopped from this and, prosecuted and punished. And so the result of that was that there were then state charges that were brought against Galea, based upon his sort of leaping and jumping about in front of everyone. And the agent's position was that they had reacted in fear, and they had stopped him and then even interrogated him in order to protect. Galea, of course, was very, very unhappy, so he actually responded to this by filing his own lawsuit in state court, claiming that the arrest was unlawful, it violated his First Amendment rights, and he was being sort of persecuted and punished in effect. His lawsuit lands in the state courts of New York, it gets removed to the federal courts, and then actually it provokes a counteraction that was brought, by, in effect, the Secret Service, but technically by Jacqueline Kennedy Onassis, as a counteraction against him seeking an injunction. The fascinating strategic footnote here is, be careful when you sue people, because you may get counterclaims seeking relief against you that would never have come if you had not sued in the first place. And that's one of the really interesting questions from his action, because until he actually sued Onassis and her family, they hadn't actually sought an injunction against him. I think they were just probably hoping that he would, take a lesson from the experience and maybe step back a little bit. Nonetheless, you now have his lawsuit and the counter lawsuit for an injunction proceeding. And so one of the first issues raised is, do the U.S. Secret Service agents have immunity for their actions in terms of stopping him and removing him and detaining him and swearing out a complaint, such that they have the right to do that, and he has no right to file a tort claim against them for invasion of his privacy and harassment and the like. And the second issue that the case raised is on the counterclaim by the Onassis family, ultimately, was the scope of the injunction. Are they entitled to an injunction, and what would be the scope of the injunction in terms of how it prohibited his First Amendment-based activities in public? Well, here's the answer to the next questions. With respect to immunity, as we see on the next slide, The Secret Service agents have absolute immunity for their actions taken within the scope of their duties. That is a broader immunity in general than other federal arresting agents. Here is the quote from the Second Circuit that affirmed and dealt with the case. Federal agents, when charged with duties which require the exercise of discretion, are immune from liability for actions within the scope of their authority. Ordinarily, enforcement agents charged with the duty of arrest are not so immune. Bivens versus 6 unknown agents, a well-known case you've probably heard of. The protective duties assigned the agents under this statute, however, require the instant exercise of judgment which should be protected. The Secret Service agents were charged under 18 U.S.C. 3056 with, quote, guarding against and preventing any activity by any individual which could create a risk to the safety and well-being of the children or result in their physical injury, end quote. It was undisputed that the agents were on duty at the time, and there was evidence that they believed John Kennedy to be endangered by Galela's actions. Unquestionably, the agents were acting within the scope of their authority. So this is a really important principle. Most federal law enforcement officials do not have absolute immunity when it comes to their arresting activity, their sort of enforcement of the law activity. They have what's generally known as qualified immunity, which may or may not protect them, or it certainly gives a lesser level of protection than does absolute immunity. And so the result then of the absolute immunity conclusion by the court is that all of Galela's tort claims were dismissed with prejudice, and that was the end of his case. But it wasn't necessarily the end of his industry, because he had now created a whole cottage industry. He got these photos, they were worth a lot of money, and he built what is now the massive celebrity and paparazzi industry. And as a footnote to you, if you are interested in learning more about celebrity and paparazzi law, I have another program as a part of the Curious Lawyer series dealing with celebrities and paparazzis, copyright law, the right of publicity, and the internet, all of which details with the fascinating and often unseemly world of celebrity paparazzi interactions. But that's a different program for a different day. Back to Mr. Galela's case. He lost his tort claim, and that was kicked out of court, but he was still the recipient of the injunction on the counterclaim. So now he has gone from being a plaintiff to only a defendant. And on the next slide, as you can see, an injunction was issued. And the court concluded that although Mrs. Kennedy Onassis was a public figure and subject to news coverage, which would generally heavily mitigate against any kind of injunctive relief against the press in terms of their activities with her, nonetheless, the court held that Galela went far beyond the reasonable bounds of news gathering. When weighed against the de minimis public importance of the daily activities of the defendant, Galela's constant surveillance, his obtrusive and intruding presence, was unwarranted and unreasonable. If there were any doubts in our minds, Galela's inexcusable conduct towards defendant's minor children would resolve it. Pretty stinging indictment of Galela and his celebrity paparazzi activities, and so the result was a very broad injunction prohibiting him from coming too close to the family and engaging in those surveillance methods that he had been engaged in. This brings us to the next component of the presentation with respect to the Secret Service, and that is protecting press access to the White House versus the Secret Service and their decisions on the press and what kind of press access we can have. And there you see a photograph of President Nixon speaking to a gathering of news reporters in the White House doing one of his question and answer sessions. And one of the cases we will look at involves some journalists and their challenges during the time of President Nixon's presidency in terms of denial of access to the White House. This brings us to the case of Sherrill versus Knight, 569 F. 2nd, 124. It's from the DC Circuit in 1977. And the big picture issue that this case touches on is really where the U.S. Secret Service ultimately collides with the right of the First Amendment right of the press to have access to the president and the executive. And so as we dive into this case, this is sort of the factual background and what happened. A journalist went and asked for a press pass to a White House event. And it was an event where the White House was voluntarily allowing the press to attend these events. These were not legally required sort of events, in other words, where the press had to attend. They were just sort of voluntary events. And this one journalist in particular sought a press pass, and that was handed to the U.S. Secret Service to assess and decide. And the U.S. Secret Service, part of their protection of the president and their definition of who may come within the zone of the president, as you remember from earlier in this presentation, they get to decide using the structures and rules that they envision for who may come near the president. And so here a journalist applied, and the U.S. Secret Service did some form of an investigation, but then denied the press pass without any explanation. The only explanation given was, quote, "for reasons of security," end quote. Sounds very ominous. Well, the journalist, not feeling like the journalist was a security threat to the President of the United States, challenged it and said, this is a sort of black box decisional process that you, the Secret Service, working for the executive, are engaged in, and that violates really my First Amendment right of access to provide news and news gathering activities. And having a black box decisional process without any explanation of what the investigation was, what it found, why I, from the press pose a risk or don't, why I'm being excluded and others are being included, et cetera, et cetera, et cetera, all the sort of buttons that you would expect. That type of a process needs to be transparent and open, and that was effectively the challenge that got brought by this journalist. And as you see, as we move to our next slide, the court found that given these important First Amendment rights that are implicated by the refusal to grant a White House press pass to a bona fide Washington journalist, the refusal must ultimately be based on a compelling government interest. Now, the court had held clearly protecting the president is compelling, if not even an overwhelming interest. But the Second Circuit held merely informing the individual rejected applicant that the rejection was for, quote, reasons of security, end quote, does not inform the public or other potential applicants of the basis for exclusion of journalists from White House press facilities. Moreover, we think that the phrase, quote, reasons of security, end quote, is unnecessarily vague and subject to ambiguous interpretation. Therefore, we are of the opinion that appellants, the journalists, that appellants, the executive, the United States Secret Service, must publish or otherwise make publicly known the actual standard employed in determining whether an otherwise eligible journalist will obtain a White House pass. Now, this is a massively significant decision that was issued in 1977 because until then, the process had been really entirely vague and opaque, and the president could hand out press passes or not, really willy-nilly using whatever internal criteria the president and the Secret Service wanted. This was the first major legal challenge to that process, and the result ultimately from the DC Circuit was that that vague process was unconstitutional as applied to bona fide journalists. And so the result was that this was the first time that, due to a judicial decision, the United States Secret Service was now subjected to the requirement that they provide some codified law, in effect, outlining the different litmus tests they would use to decide who would receive a pass and who would not receive a pass. This then resulted, as we see on the next slide, in a massive new law change. And ultimately what happened is codification of standards to decide who gets a press pass and who doesn't in terms of access to the president. And so there's now a set of laws that govern the United States Secret Service in terms of how they dole out these passes. And it works as follows. In granting or denying a request for a security clearance made in response to an application for a White House press pass, officials of the Secret Service will be guided solely by the principle of whether the applicant presents a potential source of physical danger to the president and or the family of the president so serious as to justify his or her exclusion from White House press privileges. This is codified at 31 CFR section 409.1. And as you can see, it's a very, very simple test that has to be met. I mean, it's a sort of single button test in effect. It's guided solely by whether there's a source of physical danger. If there is, one is excluded. If there's not, one should be included. Now, the Code of Federal Regulations also requires that this determination still not remain part of an opaque, vague process, but it actually must be explained. And there's significant legal requirements now that the Secret Service has to give great detail as to why they're excluding someone. The excluded applicant has the procedural due process right to file a response within a given time period to make the case that the denial was improper. They also, the excluded participant that is, has the right to demand a personal appearance before the Assistant Director of the United States Secret Service to, in effect, plead his or her case as to why the denial should be revoked. And then there's a requirement that a final decision taking account of all of those prior procedural hurdles, that decision must be issued in final form with an explanation to the applicant. That gets us to the next series here, which is protecting the president and the First Amendment. And this really gets at where the Secret Service is now protecting the president when he is out and about, and First Amendment right of access off premises from the White House. The first case we will look at is the case of United States versus Bursey. This is reported at 416 F. 3rd 301. It comes out of the Fourth Circuit in 2005 when it was reported, but the case actually began a few years earlier in 2002. And so in 2002, there was a presidential rally in South Carolina. And President Bush attended this rally. It was at a base, an armed forces base, and he was there holding and hosting a rally, at the event. And it was sort of in an area near an airport hangar on the base. And so, because he was going to be there, the United States Secret Service got to define his locale and the jurisdiction of where he was, and they got to decide who would have access and the terms upon which they would have access. And so the United States Secret Service designated a very specific area near the airport hangar as being restricted. And there was a separate protest zone area that was set up that was near the restricted zone area, but it was a specific area where if people wanted to engage in protests against President Bush and the war and all that, they could go to this protest area and engage in their protests, but they were not allowed in the restricted area. Now, this restricted area did allow members of the public to be there, but you had to have a ticket to be a ticket holder to go to that area. Well, what happened is Mr. Bursey had a ticket to go to this restricted zone, so he had been cleared to go to the restricted zone, but while in the restricted zone, he started protesting the Iraq war with a whole bunch of anti-war signs, and he had a large megaphone, and he was sort of blasting out his anti-war beliefs and statements from the restricted zone. So the United States Secret Service comes over and tells him, you have to leave. This is a restricted zone that we have defined as being one for ticket holders who are not allowed to engage in protest. He said, I am a ticket holder and you cannot restrict my right of protest. I have a First Amendment right to protest. And this is also an airport, it's a public space, and I have a full First Amendment right to be here, so I absolutely refuse to leave. He continued broadcasting on his megaphone, and you can imagine what happened next. The United States Secret Service proceeded to arrest him. He was then handed over to the United States Attorney's Office. The United States Attorney's Office returns an indictment, and the case goes to trial, and he tried to assert his First Amendment defense. He lost, and he was convicted. The case went up on appeal to the Fourth Circuit, and the Fourth Circuit affirmed the conviction. It held ultimately that the United States Secret Service has a very broad right to define what is a go area, what's a no-go area, who may enter that area, the circumstances under which they may enter the area, what types of behavior they can engage in that area, and to regulate behavior in that area, all in furtherance of their mission to protect the president. And moreover, there was a designated protest zone where he could have gone to protest, and so his First Amendment rights, the court held ultimately, were not infringed or impinged in any way. The conviction stood. So the result ultimately from this case to see is that the United States Secret Service, when traveling with the president to different areas that may be private areas, they may be public areas, they may be traditional public space areas, traditional public forum type areas that the president is then speaking to the public in, the Secret Service can, within those areas, set up metes and bounds and define this kind of moving zone that bubbles or cocoons the president with very strict rules and regulations about who may enter, who may not enter, what they may do and what they may not do. And all of that is really impervious to First Amendment challenges. So if within a given zone around a president certain speech activities are limited, the Secret Service absolutely has the right to do that without infringing First Amendment rights, where there are designated First Amendment public zone areas to engage in speech, and also, of course, where the zone isn't defined so massively as to be absurd, i.e., they can't say the president is speaking in Newport Beach today, and all of Newport Beach is a zone that denies First Amendment speech. Obviously, nothing like that. Nothing like that's ever been litigated. But the point ultimately to take is that this is a very, very broad power of jurisdiction for the Secret Service that the courts really do jealously guard. And when one goes through all of the case law, there's a very, very strong, woven thread through all the case law you see that the Secret Service determinations about how to protect the president when out and about in public are really given heavy deference by the courts, and the courts don't meddle and really don't want to get involved in second-guessing those decisions. Now, as you remember from the beginning of this program, the Secret Service's jurisdiction is not just the president. It also extends to criminal and investigative efforts to enforce and protect the United States population against other violations of U.S. criminal law, such as counterfeiting, money laundering, and other types of fraud that touch all of us. This brings us to our next slide, which kind of defines here the further scope of the U.S. Secret Service. The president obviously was paramount, but we have these additional areas that define the metes and bounds of the U.S. Secret Service's jurisdictional scope. The first is violations of federal banking laws. That falls within the purview of the U.S. Secret Service. We have violations of any laws relating to coins and coinage, money that is, obligations and securities of the United States and foreign governments' securities or obligations, so bearer bonds, promissory notes from the U.S. and the like. The Secret Service also covers violations of any laws relating to electronic funds transfers, frauds or crimes therein, and frauds or crimes involving federally insured organizations. And so in very simple terms, if you think about electronic funds transfers, you use PayPal every day perhaps to pay one of your vendors, or maybe your clients even pay you on PayPal. And those are electronic funds transactions that if people engage in using PayPal to perpetrate illegal transactions of some kind, you will trip into the jurisdictional purview of the United States Secret Service. Now, one other very unique and different area of jurisdiction for the Secret Service is that, and this is mandated by federal law, and that is that upon request of any state authorities or upon the request of the National Center for Missing and Exploited Children, the Secret Service must go and provide their forensic and investigative assistance to those organizations. And that's just a unique byproduct of the fact that the U.S. Secret Service has very detailed forensic investigative knowledge when it comes to things such as paper and ink and the like, which could be of great use to state authorities and federal authorities, especially for a whole variety of crimes, including crimes against children who may go missing or are exploited. And finally, the last bullet point you see here is that the U.S. Secret Service is responsible for investigating all threats against the president. And I do mean all threats. And here I have a personal story I can share about that. No, I never threatened the president. I know that's what you are thinking. Not true. But here's my personal story that really shows literally every threat is investigated. I was a kid growing up in Camarillo, California. My dad was a physician at Camarillo State Hospital, which was really one of the most famous mental health institutions in California at the time. And one day the phone rang, and I was 12, 13 years old. I answered the phone, and the person on the other end of the line said, "This is so-and-so from the United States Secret Service. I'm calling to speak to Dr. Afrasiabi, please." And I said, "Wow, that's amazing." So I went and got my dad and said, "Dad, it's the Secret Service on the phone. They want to speak to you." So my dad gets on the phone, and at this point, my brothers come, my mom's come. We're all hovering around the phone wanting to know, why is the Secret Service calling to speak to our dad? Well, it turns out one of my father's patients at Camarillo State Hospital, and here's a footnote to the footnote of the story. Camarillo State Hospital, at least when I was growing up, it was lore in Camarillo that the cover of the Eagles album, Hotel California, was a picture of the state hospital, and the song Hotel California was about the state hospital, particularly the line, "You can check out, but you may never leave." So in any event, that's a footnote to this footnote of the story. But we're hovering around the phone, and the Secret Service agent speaks to my father, and my father, you hear him speaking, and eventually what comes out is that one of his patients had sent a letter to the White House threatening to kill President Reagan. And the Secret Service was then conducting an investigation and a follow-up to get to the bottom of the letter, the sender, his mental health status, and whatnot. And so they proceeded to speak to my father, investigate my father, look at the files, and do whatever they do to make sure that the president is safe and that this threat is not a real threat or what kind of a threat it is. I'm quite sure the person didn't check out or leave anytime soon either after that. But nonetheless, that is an example of how the U.S. Secret Service, is engaged in this massive investigative effort to, go through all threats made against the president and chase every bunny down every hole to make sure the president is safe. Now, the final point that comes out of these slides really is that in this modern world of coins and currency, and now we're in the era of bitcoins and cryptocurrencies, those are all electronic forms of currencies and obligations that really fall within the purview of the U.S. Secret Service. So as the whole Bitcoin craze, peaks and crests and collapses and grows again and whatever may happen with it all of that will trigger at some point a variety of investigations, no doubt, and the U.S. Secret Service will be right in the middle of them. That's the role of the U.S. Secret Service and their legal obligation. This brings us, of course, to the next slide, which is financial crimes in the internet. And we have the requirement upon the Secret Service from federal law that there be advanced cyber and finance crime protection to safeguard ultimately the nation's banks and financial institutions from cyber hacks. And so the U.S. Secret Service is, neck deep in very advanced cyber and crime protection techniques and activities to protect our banking and financial infrastructure. The result of this, in part, is this forensics lab, which I alluded to earlier, and it's the world's largest ink and handwriting library and analysis database. The largest volume of handwriting analytics and different kinds of inks so that ink on letter can be interpreted and understood to know, where that ink came from, what pen, what manufacturer, et cetera, et cetera. That's all as a function of this electronic and financial crimes in the modern internet world and the the work of the Secret Service. There's also, starting in 1995, federal law required an electronic crimes task force actually be formed and created. And so it started in New York with the New York Electronic Crimes Task Force, and it was incredibly successful in ferreting out financial fraud and electronic crimes. And so Congress then expanded the jurisdiction of the Secret Service and mandated that there actually be a national network of these electronic crimes task forces that are out there to prevent, detect, and investigate electronic crimes, including electronic crimes that take on the aura of being potential terrorist attacks against critical national infrastructure and financial payment systems. So, if you're out trading stocks and you're worried about foreign terrorists attacking somehow, with electronic hacks or viruses, the New York Stock Exchange and the like, the Secret Service is the organization behind the scenes using their legal tools at their disposal to do those investigations and stop it. There's also the legal requirement that there be a financial crimes task force that exists to combine with the resources of the private sector and other local, state, national law enforcement agencies in order to address threats to the general financial payment systems and other infrastructures. And the result of that is there's actually 46 financial crimes task force also set up around the nation. So as you can see, because of the legal charter of the Secret Service, they're well into assessing and analyzing financial crimes and then prosecuting them. Now, the law actually imposes a very strict reporting hierarchy on the U.S. Secret Service. It's, as you remember, it was moved to the Department of Homeland Security from the Department of Treasury as a result of the Patriot Act and the 9/11 legal changes. But what's been very clear in the law is that it cannot be merged with other functions of the Department of Homeland Security. And so the Secret Service really has to operate within the Department of Homeland Security as a standalone organization or entity, in other words, with very strict reporting hierarchies and not, where it's not blended or merged with other DHS functions. And the result of this under 18 U.S.C. 3056 subsection G is that no personnel and operational elements of the U.S. Secret Service shall report to an individual other than the director of the U.S. Secret Service, who shall report directly to the Secretary of Homeland Security without being required to report through any other official of the department. This is a sort of testament to the legacy and the longstanding nature of the U.S. Secret Service and what it's done and its important role in staying focused on a very specific set of financial crimes. This brings us to the next issue, which is issues revolving around the warrant requirement of the Constitution in terms of how the U.S. Secret Service makes arrests when they are involved in their investigations and they come across criminal behavior. And we get an answer to this in 18 U.S.C. section 3056, subsection C1, capital C. And as you see here, U.S. Secret Service agents, quote, they may make arrests without warrant for any offense against the United States committed in their presence or for any other felony cognizable under the laws of the United States if they have reasonable grounds, I stress those words, reasonable grounds, to believe that the person to be arrested has committed or is committing such felony. Now, the question this, of course, raises is that an easier standard than the typical Fourth Amendment probable cause standard? As we all remember from our criminal procedure class, for the bar exam and in law school, the Fourth Amendment probable cause standard is a more exacting standard than the reasonable suspicion type standard that is used in other areas of criminal procedure for other types of police-person interaction events. This question was answered by the 10th Circuit in 1968, and this is the case we see on the next slide of Holt versus United States. 404 F. 2nd, 914, and it's from the 10th Circuit, again, 1968. The issue in this case, and the facts in the story ultimately, are that there was an agent of the Secret Service, an agent McWorthy, and he had an informant. And the informant told the confidential informant told the agent that he, that being Holt, the plaintiff in this lawsuit, that Holt's in the phone booth and he's got it on him, referring to counterfeit money. So the Secret Service agent who's engaged in this sort of surveillance activity, trying to stop counterfeiters, relies on the informant saying that the guy's in there with it, goes, apprehends the person in the phone booth, and finds a package with 150 counterfeit U.S. Federal Reserve $100 bills. The question then teed up was that sufficient probable cause to make the detention and arrest, and is that standard different to reasonable grounds? And the court ultimately held that the reasonable grounds standard of that statute governing Secret Service behavior is functionally the same, actually, as the probable cause standard, and that the informant's testimony that the person was in possession of counterfeit notes did satisfy probable cause and hence the statutory reasonable grounds standard. So in other words, the court avoided any kind of constitutional problem with the statute, i.e. avoided having to conclude that there was a statute authorizing an arrest on a lesser standard than the Fourth Amendment required. It harmonized the statutory language with the Fourth Amendment, and it eventually, and ultimately ducked any kind of a constitutional problem that could arise given the fact that in other areas of Fourth Amendment jurisprudence, probable cause is a greater standard than the sort of reasonable suspicion language that's often used. Here, reasonable grounds was equated as being the same as probable cause. And so the Secret Service statute's been interpreted that way, and it's constitutional, and that's a good example, really, of a fact pattern that establishes sufficient probable cause to go deal with counterfeiting. This brings us back now to the jurisdiction at the White House in terms of the protection efforts that go on. And at the White House, the security is both physical fences that the U.S. Secret Service is in charge of establishing and maintaining and controlling, et cetera, but also all electronic surveillance. And that includes electronic sensors and invisible fences and the like. They deal, again, as I talked about earlier, with all threat letters that the president receives, and there's very broad criminal remedies that exist in terms of dealing with these threat letters. I gave that personal anecdotal story about my father's patient from many years ago who threatened the president. But here's another example. This comes actually out of the case law, and this is the case of United States versus Romo. It's at 413 F. 3rd, 1044. It comes out of the Ninth Circuit, and it's from 2005. Here, you have the situation of a prisoner telling his therapist that he sent a whole host of threatening letters to the President of the United States. This, based upon reporting obligations, was actually reported to the Secret Service. It resulted actually in an indictment against Mr. Romo for his threats to the president. And Mr. Romo tried to block the indictment by contending that he had a patient-doctor privilege, in essence, with the therapist, such that when he shared with his therapist that he had sent the letters, those had to be maintained as being privileged, and the release of that information going upstream from the therapist to the Secret Service all resulted in an infirm prosecution, fruit of the poisonous tree, in other words. Well, the Ninth Circuit got the case, and the Ninth Circuit held that at the time of these threats, the therapist was not actually per se practicing his craft as a therapist. And so as a result, not every communication that a prisoner may make to a therapist is protected. Here, the conclusion ultimately was that the therapist doctor did a whole range of diverse work at the prison where the prisoner had made these confessions of threats. And not everything the doctor did was therapy-based. And so actually, factually, the court concluded that this communication occurred in a more non-therapeutic setting to a therapeutic setting. That enabled the court to duck the issue of the existence of the patient-doctor privilege and any, reporting obligations that may obviate that privilege, and conclude that it wasn't privileged. And ultimately, then the prisoner got another conviction for his threats to the president and is now serving 2 prison terms for a subsequent conviction. Our next slide starts looking at legal reforms that may be afoot in the realm and in the space of the U.S. Secret Service. And to get at the issue of the legal reforms that may be out there and that are being pondered by both the Republican and the Democratic side of the full Congress, we have to start looking at some kind of high-profile failings, so to speak, that have afflicted the U.S. Secret Service over the last several years. The first one here we have listed is from December of 2013, where a fake sign language interpreter with actually a violent past and a criminal history ended up standing within just a few feet of President Obama at the memorial service for Nelson Mandela in South Africa. And you may all remember probably seeing that in the infamous footage on YouTube and on the news. That was a person who should never have been that close to the president, wasn't properly vetted, and that ended up being a lot of egg on the face of the U.S. Secret Service. Then in May of 2014, there was an unauthorized vehicle that entered the secure perimeter of the White House, and it did that by simply following Malia Obama's motorcade through the lowered ballards as they were lowered for her to enter. Another example of the fencing and the sort of physical dimensions of the White House not being sufficiently protected. That too was highly publicized, as all of these were. In September of that year, 2014, an armed contract security guard who had a prior arrest for reckless conduct with a gun actually rode in an elevator with President Obama when President Obama was visiting the Centers for Disease Control in Atlanta. A few days later, in September 2014, another armed individual, or this time an armed individual, jumped the White House fence, outran actually the Secret Service officers, which may beg my earlier comment about how you'll never outrun the Secret Service, and actually entered the White House, making it all the way to the East Room before ultimately being tackled and taken down. In September the 27th of 2014, another event occurred where a man was posing as a member of Congress at a Congressional Black Caucus Awards dinner where President Obama was speaking. This man posing as a member of Congress actually managed to breach a secure area backstage and even managed to hang out and chat with President Obama for a while backstage. In January of 2015, there was the other highly publicized event where a drone actually crashed onto the White House lawn, prompting a whole bunch of news reports, as you may recall at the time, that the White House radar system literally failed to pick up the existence of this drone and this flying object as it entered White House airspace. In February of 2015, two individuals gained unauthorized entry to the outer security perimeter of the White House simply by walking in unnoticed. All of those plus others you can go read about in this committee report that's been put together by the Congress, by a committee of the Congress, entitled U.S. Secret Service, an Agency in Crisis. It's from December of 2015, and the link is there where you can get it from the house.gov document depositories. In any event, all of those high-profile failings have led to a lot of questions about the scope of the U.S. Secret Service's jurisdiction, its legal placement within the Department of Homeland Security, and what can be done to fix it to avoid future problems so that this really important mission, this critical mission of the U.S. Secret Service can always be carried out safely. This brings us to the legal reforms on the next slide. The first point is that because of its insular nature, Congress has required that other agency employees make up the Security Appeals Board to manage whistleblower complaints and misconduct investigations. This is the beginning of the legal reforms to manage how they get to the bottom of when these charges are coming out and whistleblowers are happening, how these people are comfortable to come forward and what can be done to make sure that they're able to whistleblow and such that misconduct can be found and investigated. And one of the recommendations that Congress has made is that there's a need for agency leadership coming from outside the agency rather than always up from the bottom, which has created this sort of insular culture that Congress believes. Congress also has demanded interagency review with proposals for the U.S. Secret Service to act upon. And the final issue that's been raised is that after the 9/11 shift from the Department of Treasury to the Department of Homeland Security, there's been real bipartisan concern voiced about the appropriate legal house that the Secret Service should sit in. And here you see a quote from a Republican member of Congress from Utah who's quoted as saying, long-term, the 60,000-foot view, there are some who are very critical of the switch that the Secret Service went through after 9/11. The Virginia Democratic Representative Jerry Connolly agrees, and so the question that's really out there is that will the Department of Secret Service return to the Department of Treasury where it began in 1867? And given the sort of legal wranglings afoot and the legal discussions afoot in these legal committee meetings that have been occurring, it does seem likely, given the financial crimes and the ever-expanding jurisdiction of financial crimes that's out there. This brings us finally to the concluding section of our Curious Lawyer series on the Secret Service. As with all of the Curious Lawyer programs, we end with some fascinating little legal myths to debunk the legal confusion that may surround this topic of law. And so we're going to start with legal myth number 1 about the Secret Service. The Secret Service is allowed to turn a blind eye to crimes being committed by those it's protecting. Not true. You see there the screenshot I took of a famous Clint Eastwood movie from the early 1990s where the president was hurting someone and the Secret Service was sort of covering it up because they were participating in it. That movie captured kind of that urban legend. There's actually no law that allows or provides any such discretion to the Secret Service to simply turn a blind eye if someone they are protecting commits a crime. In fact, the reality is that under our criminal codes, their failure to report a crime that someone they're protecting is committing, that failure to report could actually make them an accomplice. This gets to the question of whether there's a protective function privilege, and that was answered by the D.C. Circuit in 1998 that there's not. That case comes out of the Bill Clinton, Monica Lewinsky investigations where Ken Starr served subpoenas on Secret Service agents. The agency argued that there should be a privilege, that they shouldn't have to provide and respond to the subpoenas, but the courts said absolutely not. Congress by law requires them to be physically near the president, but Congress never said that their interactions with the president are subject to any kind of a privilege or exemption. And so then, as a result, several agents did in fact have to provide information stemming from Ken Starr's investigations. And the same thing unfolded in the Watergate hearings where several Secret Service agents were required to testify, and the conclusion was that there's no privilege. So they're never allowed to turn a blind eye to crimes, and the people they're protecting don't get a free pass on engaging in crime. Myth number 2, by law, they have to take a bullet for someone they're protecting, for the president. You probably all know the famous statement from the Secret Service agent Clint Hill, who was there during JFK's assassination, where he said, "I wish I'd been quicker," saying that he wished he'd been able to take a bullet. There's actually no law, and there's not an oath either, that requires a Secret Service agent to take a bullet for the president. Now, I will say the reported custom when you do the research and speak to everyone is that the custom is that they all agree by custom they will absolutely take a bullet for a protectee. And indeed, they actually engage in training to train on how to try to take a bullet for a protectee, to practice for such events. But it's a myth, again, that the law requires it. And the final myth, as you see here with a photograph of President Coolidge's wife, Grace Coolidge, with her favorite dog being guarded by a Secret Service agent. The myth is that they protect the president's dogs and pets. They do not protect the president's dogs and pets. That's a myth. The definition of family under the U.S. Code in terms of their obligation to protect the president and the president's family does not extend to the pooch. That brings an end to this program on the U.S. Secret Service. I hope you found this interesting little whimsical walk down U.S. Secret Service law interesting and fascinating. Check out my other programs, please, on the Curious Lawyer series. Thank you.